God is wanting to bali mikuwana
worship we are before. Grand friend, Mr. Thomas Datika, Mr. PPP, and Mr. Richard Milipanda on stage, and Mr. Elias Ukwago, Self-Patrick Mkanda, Apollo Katumba, Akupeta Sekandako, Cyrus Oju, Brian Limawe, and Mr. Kamilebia. So, worship just before my colleagues come, or they haven't started. So just so that we don't get them by ambush. Just thought we should emphasize.
No, my Lord, I think at this level, with all due respect, it is the respondent that, or the applicant, the respondent in that application, that made a prayer to stand over to make up. So, if the applicants have anything to say, let them wait in the beginning. There is nothing to clarify right now. They had all the time. It was the application, not this application. It looks weird for the applicant to come and say, before he comes, let me clarify. We are ready to respond and we are ready to your worship.
Worship, what if we want to submit an offering?
It should have been submitted that
My
time.
Lord, and the worship, I think it's a court of law. And seek leave of court. Mr. Bitabuse, even though he has the might of the state, is just like us, he's ordinary. So you shouldn't assume that because he has the comfort of an office of DPP, he can come here and push us around. I am seeking the leave of court, address court before he comes on, because it will help him wouldn't bring this situation. I am seeking leave of court.
Your worship, there is nothing to see on it. First of all, this court has a discretion to grant leave or not. There was an application which was made by senior counsel as well, and he ably submitted. He shook this court in his submissions, and that's the reason why we applied for standover to have our response. It is therefore not fair for them to make bad and good their own case before we respond. Let them allow us to respond. There's nothing we need from the applicants to help us. It is the application, so we pray that the application for leave to make clarification is denied so that we respond, because they have time to rejoin.
Well, before we stepped out, the applicant had actually put his application before court, and it was the respondent who asked for his standover. So let's listen to the respondent.
Most obliged. Josh, in response to the application, first of all, by the time Senior Counsel Rukwago made the application to stay the proceedings and also asked for the record. This court had made a ruling to the effect that the application number 01 of 2025 be had in chambers as the magistrate or the trial magistrate was standing up. Counsel simply said has an application to make. That in itself was irregular. Because at that time, the hands for applicants and the respondents were tied because the ruling had been made. The only way senior counsel was by all means supposed to make that application was to seek leave of this court, which he never sought. That in itself hits the applicant's hands down. That said, my senior colleague talked about so many things, including jeopardizing the case for the applicants. However, we on record as prosecution for ensuring an expeditious trial, an expeditious investigation in this matter. We wish this court to take a note of the fact that the prosecution is being twisted by the accused persons, in which case the intention is to delay both the investigations and the trial. So, on the other hand, as the prosecution is trying to execute its mandate, it is being blocked, it's being frustrated, it's being twisted by the defense, which shouldn't have been the case. We expected the defense to be the main facilitators of the first investigations and the trial of this matter, but we are surprised. Defense made an application and cited several provisions of the law. He cited section 17A of the Educator Act, 17.1 of the Educator Act, which talks about the supervisory powers of the High Court over Magistrates' Courts.
As long as I'm not captured.
No subline. And also cited there, he cited the section 33 of the Educator Act. Let me read it verbatim, because you want the press to hear. They are bringing this application under section 33, which talks about treatment of life imprisonment or imprisonment for life in any enactment. That is the law under which the application was brought. This is bad law. This is bad law. You watch the details are there, and we wish God to capture it as part of the application. 2, counsel made a prayer to stay proceedings, that this court stays on proceedings. However, that assertion, or that prayer, sorry, is not grounded. He never provided or cited any authority, either statutory or case law, that gives this court, empowers this court to state its own proceedings. In a scenario where it has been just informed by the applicants that they intend or they anticipate to make an application for revision in the High Court. This court is not supernatural. This is not a court of prophecy that will determine that the applicants are going to make an application for revision in a 2 or 3 or 1 month time. The only court that has the powers to stay the proceedings before this court is the court that is doing the revision. And therefore, the applicants to that effect in this application should first of all have sought that order from the court that will hear the application for revision. Because that court has control over proceedings before it. And therefore, it can tell the timelines that the said application will be heard and disposed of. Which luxury, your worship, this court doesn't have. And therefore, it is redundant. It is a redundant prayer to ask for stay of proceedings in a lower court. This court cannot again stay proceedings before it without evidence that an application for revision has been made. We don't operate in anticipation. Courts of law operate on facts and evidence. So the issue is, what if the applicants file the application for revision after 1 year? So our view, my colleague will submit on the record of proceedings, but I am of the view that this court does not have powers to state its own proceedings without grounded statutory law and case law. We were supposed to have this matter heard in chambers, and I believe that this court will not have erred in any way to have application number 01 of 2025 heard today and disposed of, so that we fast track the investigations in this matter and ensure a speedy trial for the applicants in the main case, that is 008 of 2025. The public, your worship, my senior colleagues have written about that, how it is going to be placed. The public and the press have less contribution in application number 01 of 2025 because they are not going to make an argument before this court. None of them saw an affidavit on record. And therefore, their input is at the periphery. Yeah? Their role is peripheral, if I'm to say it. My colleague will add on that.
Your Honor, for the record, I'm the people Thomas as a standing deputy. Your Honor, it is very prudent that the sections that have been cited by our land friends, that is section 17, which gives supervisory powers to the High Court over the Magistrates Court, and sections 48 and 50 under the Criminal Procedure Code, that purpose they relate to the nature of proceedings in revision, gives the High Court these powers to call for and examine the record of any criminal proceedings before a magistrate's court for purposes of satisfying itself as to the correctness, the legality, the propriety of any finding, sentence, or order recorded or passed, such as the one dishonorable court gave, and as to the regularity of any proceedings of the magistrate's court. These powers are solely given to the High Court, and therefore, for the defense purports to ask this honorable court to inherit itself of these powers is not correct. The legal court that my colleague earlier commented on or submitted that they should have sought leave from this honorable court, it is their right to apply for a record of proceedings and ruling of this court. However, for it to be the basis upon which they want to file an anticipatory revision, it should not be entertained by this honorable court. And it is our humble prayer that it is misconceived and they should file this application before the right court as they are allowed. And we pray that this honorable court be pleased to have this matter heard as directed and in its order. So now.
Thank you, Your Worship. Your Worship, what I wanted to do was to put things in clear perspective. Yes, I am responding. So that my colleagues respond appropriately. My senior colleague, Mr. Kwame, premised the application, section 48. That was his section. He referred to section 17 in support of section. What he said was that we have instructions to refer the matter to revision. It is in section 48 and not section 17. Your Worship, under the Judicature Criminal Procedure Application Rules, SI 13-8, that process can be commenced by letter. It is therefore erroneous and perhaps deliberately so, because I don't want to assume that he does it, that you don't need to file an application. So when council says we can't file an application in 1 year, I don't want to assume that you are letting go of the full process. It would ensure take council 1 year to write it. In any event, the letter has been written, and perhaps the system would have shown you that the application is there. Your Worship, the instructions of the applicants are to seek a revision, not an appeal. The sections cited do not require leave of this court and it to be a fire. We are not here to ask for permission of this court. It is a right to refer the matter to the bishop. It is nowhere indicated that we must seek permission of this court. So again, because I know that Mr. Bitabuse cannot see this, I don't want to assume that circumstances are causing him to do what is wrong, especially when it's still the other part of the month, when all of us have just been paid. Your Worship, I agree, it is my style to be emphatic, that when the government has injected resources, we ought to do the right thing, because that's what we are called to do. So, Your Worship, what Land Council Elias Okago said was to inform court that we are going up to higher court. We repeat, we do not need permission of this court because it's not provided for anywhere in the law. It also ought to be remembered, Your Worship, because Council has said we should have filed an application. We don't have the benefit of lead cards like him. This matter was stood over for 30 minutes. We could not go away and file an application and come back to this court in 30 minutes. We were just good mannered to say we are going to a higher court. Please hold on until the higher court makes a pronouncement about the matter. My colleagues referred to the lack of an authority. It is what I was going to refer to when he quickly stopped me. Unfortunately, now that he stopped me, we wouldn't have an opportunity to respond to it because he would have only been a little patient. Your Worship, it is common sense that if the High Court is going to review proceedings in the lower court, the file of the lower court must be before the High Court. So when the application is filed, and it will indeed be filed today, the High Court will make a pronouncement to call the file. For this court to proceed with the cross-examination in camera and end today, when we are seeking a review of that decision, would surely not make sense. That's what I'm saying, it's common sense. Because then there will be nothing to review because the cross-examination has happened. We don't want to take the deponent through the bother of returning if the court says that we should do it in the open. It's common sense. Your Worship, also, the spirit of our argument is founded in the well-known decision of Charles Onyango Obo and Andrew Mujuni Mwenda versus the Attorney General. Your Worship is the one I wanted to point my colleague to when he said I shouldn't. In that court, I know it is Constitutional Appeal number 2 of 2002, Supreme Court of Uganda. His earlier submission was that the High Court doesn't bind this court. I hope you will agree that the Supreme Court binds this court. Your Worship, in that decision, the Honorable Justice Mulenga, RIP, who delivered the lead judgment, say that when a court seized with a matter becomes aware that the proceedings are under challenge or are going to be a subject of a challenge, it must wait for the decision of the higher court. The rationale is to avoid a travesty of justice and to avoid applying the law or taking action whose validity is questioned. In other words, it should wait for the higher court to make a pronouncement as to whether it should continue or not continue. That is what they are saying. We are going to the high court, which, in as far as we know, is higher than this court, and it is only good, even for the record and the judicial system, to wait for the higher court. Your Worship, want to avoid a scenario, as happened in the decision of the Honorable Moses Kasibante and Paruminda C, where the lower court went ahead to conduct a recount, despite the matters being challenged by the High Court before the Honorable Justice V.F. Musoke Kubuka, R.I.P., whereby the judicial office at the lower court became a subject of disciplinary proceedings. We want to avoid that scenario and say that let the court wait and we go to the High Court. We are reminded by the Worship, and we go to section 50, subsection 2 of the Criminal Procedure Act. Your Worship, the position of that section, section 50 and section 2, is that a review cannot take place without the DPP being heard. So those proceedings of under review, these ones are going to be under review, are going to involve the DPP. It is in that forum that the DPP is heard always. The DPP cannot object to an accused person seeking to enforce their right. It is wrong. I want to assume that if my two colleagues were in the dock, they would be ashamed and angry at someone standing in their way of enforcing their right. So it is wrong for Mr. Billy Kumbuka to argue that when an accused is seeking to enforce their right, they are frustrating a process. The accused persons are not the authors of the law. They are relying on a provision of the law which they are entitled to. It doesn't matter that relying on that provision of the law causes proceedings to stay. It is their right to do so, and they are fully entitled to invoke that right. In any case, Your Worship, unlike the state and these two representatives here, it is the accused person who have no liberty. So if the delay is going to cause them to go back to prison, I shudder to think of the concern of Mr. Billy. They are taking the risk of sacrificing their liberty to see that the right thing is done. And they are empowered fully to enforce their rights. Your Worship, I wish to conclude. By saying that the arguments by my colleagues cannot stand in the way of the rights of their people persons. The rights are provided for by law. They don't have their liberty. If they choose to invoke that right, they take the inconvenience that comes with invoking that right. And lastly, Your Worship, because our colleagues blamed us for bringing this application before we filed a formal application, we just state that this court stood over the matter. The accused persons were returned to custody, which is under very tough guard, as can be seen. We didn't ask, so we didn't speak to them. We had to obey orders and stay here and wait for court. But again, as my land friend Mr. said, we are not asking this court to revise this decision because it doesn't have that power. We are asking the court to do what we think is reasonable, to hold on to continuing with the decision it made until the higher court revisits that decision. It is not an appeal, it's not brought under section 17, it is brought under section 48, which if once the application is filed, the High Court will call that file. So it is not proper, Your Worship, to take your time to sit in an application to hear cross-examination when there is a possibility that those proceedings will be recorded if the court agrees that the hearing should not proceed. That's our submission.
I respect to only the issues. One, the jurisdiction of this honorable court in regards to stay of its own proceedings. Our friends across the aisle argued that we do not cite any provision enjoining this court to stay its own proceedings. In other words, they are suggesting there is a vacuum strongly contained the famous of the law. You don't leave any vacuum in Africa. On the contrary, Your Worship, this court has unfettered powers to manage its own proceedings and processes in situations of this nature. We refer you, Your Worship, the provisions of Section 9 of the Magistrates Courts Act. If I may, Your Worship, just for emphasis sake, to read it out probably, how general jurisdiction is exercised. The jurisdiction of a magistrate's court shall, subject to this act and any other written law, limiting or otherwise. Yes. Let me get this one, read it from this volume. How general jurisdiction is exercised. The jurisdiction of a magistrate's court shall, subject to this act and any other written law, limiting or otherwise relating to the jurisdiction of that court or of the presiding magistrate, be exercised in conformity with the law with which the High Court is required to conform in exercising its jurisdiction by the Judicature Act. Your Worship, my interpretation of this particular provision, this court is broad with wide jurisdiction, just like the High Court has got or enjoys that wide discretionary power in managing its processes. And I think this answers their question as to the applicability of Section 33. Since now they are satisfied that Section 33, the former Section 33, so from the Judicature Act. Therefore, here we are getting acclimatized to the revised definition, and that's no big deal. So, Your Worship, why the discretionary powers enjoyed by the High Court under the Judicature Act are the same discretionary powers vested in this Honorable Court, including powers to stay its own proceedings. And this reinforces the issue of logic that my young friend succinctly submitted on that particular event. And that also resonates with the spirit of Section 43 of the Judicature Act. That is the former provision package. I wish to correct that information. Having said that, Your Worship, just to re-emphasize it, because now they argue that what if it takes a year before we file? That again brings me to the powers under Section 9 of this matters to manage its own proceedings. Your Worship, you have powers to set timelines. To say, yes, we recognize you have a right to seek for the intervention of the Superior Court by way of revision, but it's not an open check. And of course, we can draw parallels with appeals. That's why even appeals have got timelines. That you have a right to appeal within 14 days. You have a right to appeal within 30 days. So it's very simple here for the court to invoke its powers under Section 9 and 43 of the Section 9 of the Magistrate Council Act and 43 of the Judicature Act to say, yes, we recognize you have the right, and you have clearly indicated that you are pursuing that right. We are adjourning these proceedings for a period of 2 weeks, those are 14 days, within which that right should be exercised. And in that way, justice will be done. But now look at the absurdity. If you were to deny that right now you retreat to the chambers, you go ahead with cross-examination, but still tell the accused persons or the applicants in this matter that you have a right to seek for revision of my order, when actually you have proceeded with a cross-examination. Would that really make sense? This is what we are trying to avert. That actually, if you proceeded that way, Your Worship, you'll be rendering the right to seek for revision illusory. It will be nugatory. It will be useless. And that will be a travesty. And that's what we're trying to challenge. And actually, it will make matters worse. And it will reinforce further our application for revision if you consider it, Your Worship. To reinforce
Councillor, you said you had 2 points.
the last one, Your Worship, the accusations made against us. Very, very unfair. I don't know the words Mr. Balibu used. Arm twisting, blackmailing, doing this. He used lots of words. They were very, very uncomfortable. Very, very uncomfortable. I think he owes us an apology. He should retract those statements with an apology. We are here to facilitate this court to dispense justice, not to block the way to justice. If anything, actually, it's our client who are craving justice, who are interested in having justice done to them. This is not justice to Mr. Balibu. It's not justice to any of this, but it is justice to the applicants. So it would be very, very unfair, gross unfair, to tell the accused persons who are seeking to enforce their rights, to get justice, that they are twisting the court, that they are blackmailing the court. Very, very unfair. So I pray that he reflects on this, and before ruling is made, he accepts to have that expanded from the record. I am appealing to his good self and conscience, to his conscience. I do so pray, Your Worship.
Your Worship, I think defense should be the one to apologize. Because they have been using very, very hard and disgusting language. So they should be the ones to apologize to the prosecution. we have nothing to apologize in this respect. We are being more cordial, we are being courteous, we are being professional, to mention but a few. And God and the public can attest to this.
We seek to apologize to our colleagues for being extremely aggressive and steadfast and quite emphatic and perhaps overboard, but for the purpose of seeking to see that justice is done to our clients who are facing a charge which has a sentence of death and which is being pursued by our two colleagues to whom we do apologize.
Let's subscribe, and you make sure you subscribe, and you're very many here when I'm liking a video. Once again tell you, please don't go without subscribing and like the video. Liking, you are watching Extreme Media UK. Without subscribing. oli ku Extreme Media UK nkusaba busabe togenda nga tusubscribinze te bwoba wakatuuka wano please mulakinga video eno era tuli live nakawakoti. I'm sorry for that matter. Magistrate agaanye omulaga mu kamera bannange. But please, if it is your first time here, you subscribe and make sure you turn on the notification bell.
This is the ruling. Having heard from both parties involved, it's true that the application for revision is not yet filed and therefore anticipatory at this point in time. The normal procedure, as the defense has put it, is to file at High Court, which calls for the report. They have, however, indicated that time is of the essence, and since the court made the ruling this very day to proceed with the cross-examination, should court continue with the hearing of the said application, the rights of the accused applying for review will be clamped upon. Yes, this court can stay its own proceedings, but only upon proof of an application at High Court, for which the High Court itself will call for the file, not in cases of anticipatory matters to be filed. However, to enable the accused persons exercise the right, this court shall adjourn this matter from mention to the 30th of April 2025.
Alright, omulungi ali ku Extreme Media UK. Mulakinga video ate weguba gwe mulundi gwogusoose okuba nti no obeera ku Extreme Media UK. Please subscribinga, likinga ate era commentinga. Ekyaliyo omusango omulala.
Time for the
Let please, Your Worship. I think the introductions are being made initially.
Your Worship, for the record, I'm Councillor Simon Nsonga, representing Campaign Peninsula. Simon Nsonga.
Your Worship, this matter is coming up for nation and inquiry in the Senate. As you forward. Expedite those inquiries.
All the case persons are covered and disengaged at
kale omulungi eyekumidde ku Extreme Media UG nyongera okujjukiza nti subscribinga likinga ate era commentinga omusango Dr. Kizza Besigye alinga atwalibwa kubanga ze tugaane omusango bagwongeddeyo okutuusa ennaku z'omwezi nga 30th April. Akale embeera bweti bweri wano ku kooti enakawa nga omusango bagwongezaayo paka ennaku z'omwezi nga 3 omwezi ogwokuna olunaku olwaleero saawa zino. Bambi mbadde nkusaba obanga gwe mulundi gwe ogutula wano ku Extreme Media UG, please don't go without subscribing. Yeah, when you subscribe and make sure you don't skip the adverts. Kuba unafu wetufunira ni to skipping advert omukyala ya oli omulala gwe basiba naye oyo omukyala wa omukulu Obedi gwe basiba ne Dr. Kizza Besigye, oyo omukyala oyo gwoli mu kulaba era nga tugenda kulaba information Lord Mayor atugamba ki.
No,
Alright, tugenda kubanga tufuna information ni Lord Mayor ye atugamba ki Lord Mayor ye ajja kuba atugamba ki kye tuli mu kulinaano essaawa zino abeere nga atubuulira omukulu Lord Mayor. Subscribinga okubanga gwe mulundi gwo gusoose otulaba wano ku Extreme Media UG. Please don't go without subscribing. When you subscribe, you make sure you turn on the notification bell so that you'll be updated. I repeat again, don't go without subscribing. It's a request. Don't go without subscribing. And you are watching Extreme Media UG. My name is Jogeza Nicholas, aka John Paul UG. I'm the one behind this camera. I'm trying to show you what's happening at Nakawa Court. And what you should know is that the court, the case for Dr. Besigye and Obedi Tale have been adjourned till 30th April. That's what's happening at the moment. Jogeza Nicholas, aka John Paul UG is my name. Thank you so much for always keeping it Extreme Media UG. I really appreciate for the love. Kindly don't go without subscribing. Yeah man, and I once again tell you that if it's your first time here, please, when you subscribe, make sure you turn on the notification bell for all updates. Alright, we want to know what areas Lukwago, the Lord Mayor, will tell us what's next, because I heard of the hard court. What's happening? What's next? All you need to do is subscribe, like, comment and share the link to everyone so that he or she gets to know what's happening in Uganda. We are Extreme Media, and remember, I once again tell you, we are the CNN of Uganda, and we are the Al Jazeera of Uganda. Extreme Media is the Al Jazeera of Uganda. We try our level best at least to show you what's happening. Please subscribe, like, comment and share. Badde ngamba yi ani akoze ate Aaron Kiza bamuwadde bail era nga bail just ebadde expensive. Bail yabadde ya bukadde 20 naye nawuliddeko ne wano nti oguddako bayinza okuba nga bagenda kuwa bail naye nga kirabika bagenda kusaba sijja kubyasa naye nabiwuliddeko mu luvuuvuumo. So Aaron Kiza namuwadde bail naye ya bukadde 20. It was an expensive bail. It means justice in Uganda is expensive. That's what you should know. Kindly, if it's your first time here, please don't go without subscribing. You are watching Extreme Media UG.
But if it's ours, no mind to get
era twabagamba nti muleete omusajja Benedict Odyek eyasweyalinga affidavit ng'agamba y'omu ku banoonyereza abapoliisi tumubuuze ebibuuzo atunyonyola kikyayagala mu masimu ago nti abo bagamu n'ebirala byesijja kwogera wano tulinaffe ebibuuzo byaffe byetwagala omubuuza kyewunyisiza okutuuka wano nga state bano baprosecutor bagati twagala ebibuuzo ebyo babimulirize mu kamera eri nga banamawulire tebaliwo nga ne public eriwo ne mu chambers tukwate n'enzigi tuziggalewo bateekeko nekufulu esibire eyo tumubuulize eyo mu nzikiza ebiba eyo public ereme bimanya ekyo kitwewunyisiza nnyo ne twebuuza kiki kye bakweka bw'abanga ddala ayogera mazima nga byayagala bya bujulizi ddala obugamba nti bwaleeta mu kooti lwaki ayagala tugende twekweke tuwakanya okusaba kwabwe ensonga zaffe tuziwadde nga tugamba ffe twagala ayimirire mu kaguli wano witness stand annyonnyole tumubuuza akana n'akataano naye ate era muwulidde state yo ng'egamba nti nedda bo baagala bagende mu kamera so kivuddemu omulamuzi nakkiriziganya ne state n'akola lulingi naga nti okusinziira investigations zikyali ku stage esooka waliwo ndowooza ebintu bye baagala okukola nga byankiso babikolera eyo mukukutu mu chambers ffe kituwakanyiza tugaa nti bw'obanga osazeewo eno kooti waliyo ate kooti ezisingako twagala kweyongerayo mu kooti kino kituwakanye mu nkola gye bayita eya revision kooti eyawaggulu high kooti erina obuyinza obwetegereza mu biragiro byonna kooti eno eyawansi byewa nebaako bwebisalawo oba ebikyusaamu oba ebimenyawo oba ebikkiriza kati ekyo ffe kitusabye naye state era nekiwakanya lwero tuli basanyufu final omulamuzi akkiriziganyiza naffe naga nti ayimirize ebyokugenda maaso ne cross examination oba okubuuza mukulu Benedict Odyek mu kamera oba mu chambers okutuusa nga tumaliriza okugenda okujulira kwaffe mu high court era omusango ne gwongezebwayo ennaku za mwezi 3 mwezi ogwokuna okujja mu mention okulaba nga wetutuuse so kati ffe tugenda maaso n'okukola enteekateeka yaffe okuva olwaleero okulaba nga tuteekayo okujulira kwaffe kankuyite okujulira naye mu mateeka tekuba apiiri naye mu Luganda kwe okujulira tuteekayo okujulira kwaffe kusalawo okugamba nti Odyek Benedict bagenda tulina mu cross examiningira mu kamera oba mu nkukutu tugenda tekikkiriza era ekyo tukiwakanya ne sekuwakanya twagala kiragiro kya kooti eya kooti egambe nti tumuteeke mu lujjudde wano mu kooti amawulire wegali ng'abantu bonna we bali ebibuuzo bibuuzibwawo kubanga state ye yatandika dde ebintu bino era negenda ng'egira ebintu byejyoteka ku Dr. Besigye kubaka twebuuza yo lwaki state yennyini eyatandika okufulumya ebintu ebitalina mutwe n'amagulu nefulumya bu audio nekama muwulirize simanya Besigye wuno alamuze mundu simanya Besigye wuno agenzaako okunoonya esente Sweden Greece ziwuno simanya luddawa ne batandika okuteekayo obuloboozi obwo bagezeeko okuprejudicinga case kakati babuteekayo era mwalaba n'ennaku ezo nga boogera n'ebigambo bingi abasajja nga bamwenda nga boogera ebigambo bingi oyo Besigye yali agala kutta Museveni oyo Besigye ayina kino obujulizi buno obujulizi tubulina ne bademerako bonna bawulira obujulizi bakulayije bonna bagamba obujulizi tubulina kati mukweka bwaki muluteeke wano mu lujju bw'aba Odyek abulina jangu wano yimirire mu kagulu tugende kubuuza akataano ku bibuuzo lwaki otayagala bagende mu lujju so ekyo tugenda kulemerako era tugenda kooti eyawaggulu
state egana nti muzanya bukodyo okuterenga justice mwe bennyini
ebyo situjja kubiddamu kubanga ffe twagala obwenkanya mumanye ennaku Dr. Besigye n'Obed Jalezi bamaze mu kkomera babakwatanga 16 Novemba omwaka oguwedde ne babatwala mu General Court Martial ne tuguba ne tuwaana olutalo Sematalo ne tuluwangula ennaku z'omwezi 3 mu January ate era ne bajemera ebiragiro byabundi nga bazanya jambo okwekula ebya Supreme Court ne balwawo okuleeta Dr. Kizza Besigye bagambye nti investigations bakazitandika so babanga wakwata Dr. Besigye ennaku z'omwezi 16 omwezi ogw'2024 kakati tuli wano mwezi gwa kuna totandikanga ku investigation otandika butandisi ogamba otya nti failed to delays ani yabalemesa okuteekayo application eno